everyone, I'm Jenny, a lawyer currently working in the ethics department. Today, we will be looking at issues pertaining to concurrent loyalties. The fiduciary relationship between lawyers and clients encourages undivided loyalty by a lawyer to the client. Issues of loyalty and concurrent representation arise when there is a conflict of interest between the multiple clients involved. Let us now look at a scenario that exemplifies these issues. Romeo and Juliet are a recently divorced young couple. Romeo seeks Michael Ross to represent him in the division of assets following the divorce. Michael Ross is an associate employed by Spector Pearson firm in Sydney. Not only is he committed to assisting his clients through difficult times, but is also enthusiastic about achieving the best outcome for his clients. He's also a firm believer in the freedom of information and is passionate about family law. Michael's firm also has a branch in Newcastle, which is currently acting for Juliet in an estate dispute. This matter has yet to be concluded. However, negotiations have advanced to the point in which the value to be distributed to the wife has been determined. Juliet's lawyer, Saul Goodman, is familiar with her finances and assets. The firm's conflict check failed to recognize any potential conflict of interest in these matters, as it only cross-references existing and historical cases within the specific branch. Furthermore, Michael used to work in the Newcastle branch and is friends with Saul. While chatting after work, Saul mentions how one of his clients' estate dispute matter is being finalized and discusses details on how he was able to negotiate for his client to be distributed $750,000. Michael soon realizes that Saul's client is his client's ex-wife, but says nothing, believing this will later be disclosed by the ex-wife in her disclosure of assets. However, this inheritance was never disclosed by the ex-wife. Here, Michael, who's Romeo's lawyer, has real information about Juliet relevant to Romeo's interests, which was disclosed by Saul through a possible breach of confidentiality. To act morally in such a situation, Michael could rely on the ethical framework proposed by Rest and Brecky. Now, let's have a look at the steps in this model. The first step of the model is awareness. Awareness means realizing that the situation contains morally salient features, aided by moral sensitivity. There are two types of moral sensitivity, general and specific. General moral sensitivity is the awareness that a certain class of situations may have morally salient features informed by prior moral reflection, direct instruction or supervised work, or formal ethics education. Specific moral sensitivity is the awareness that the current situation possesses morally relevant features informed by alertness, perceptiveness, experience, and/or strong listening skills. Barriers to moral sensitivities are compassion fatigue and scripts, which are established routines that has not incorporated moral elements, which then may lead to moral blindness. Now we turn to the stakeholders' interests in this scenario. Both the lawyers involved would want to avoid ethical misconduct, achieve the best result for their respective clients while preserving the friendship between them. Whereas the clients Romeo and Juliet would want to achieve the best possible result in their divorce proceedings. In addition, Julia would also want to ensure that Romeo does not find out about the $750,000 she earned in the estate dispute, as this may influence the result of the divorce proceedings. As for the law firm involved, they would want to prioritize their reputation while minimizing the number of clients they lose. More broadly, the legal system would also want to preserve
Stage 2. Judgment. Michael should now turn his mind to forming a correct judgment about what moral duties are required in the situation. Moral reflectiveness is required to do so and includes cognitive capabilities such as clear critical thinking to form an accurate picture of the situation, and the capacity to identify all alternative courses of action. Relevant obstacles which can sway Michael's thoughts towards unethical considerations include self-serving excuses and self-deceiving rationalizations. Robert Norton's Sternlight also outlines social and cognitive biases that contribute towards creating ethical blind spots, diminishing moral reflectiveness. This can be problematic for situation-appropriate judgments. Group norms are especially relevant here considering Saul's behaviour, with studies showing lawyers are more likely to act unethically if they observe peers in their group doing so. Job stresses also push moral deliberation onto the back burner, with unethical dimensions less likely to be recognised and more likely to be succumbed to through stress factors like unrealistic performance targets, job insecurity, and cognitive depletion. In coming to a judgment, Michael can look to the professional rules and case law for guidance. In Rule 4, the ASCR provides that a solicitor must act in the client's best interest. Rule 11 addresses concurrent conflicts. Rule 11.1 addresses the prescription on conflicts of duties, which ties in with the fiduciary duty of undivided loyalty to the client, as in such a situation, the duty is almost always unable to be fulfilled for all clients. Rule 11.2 provides for where duties to act in the client's best interests conflict in their concurrent representation in the same or related matter. Rule 11.3 reflects how clients may relax conflict of interest rules by giving informed consent. With informed consent, O'Reilly has established that full candour and appropriately complete disclosure is required, and that a client cannot have given informed consent without knowledge of the conflict's existence, scope, or its implications. The case of Law Society of New South Wales and Harvey outlines that the disclosure of material circumstances and everything known which might influence client conduct is crucial. Rule 11.0 goes on to outline how a conflict of duties arises with the possession of confidential information. The solicitor must not act for the second client here, except where there is informed consent and effective information barriers. The prescription to avoid concurrent conflicts extend to the firms, which is in no better position than a sole practitioner as put in Blackwell. Reflected in Neal is that it is the firm that owes a fiduciary duty to its clients. Hence, lawyers in the same firm typically cannot act for clients with adverse interests. Generally, a firm cannot act both for and against the same client concurrently, where there is some reasonable relationship between the two matters, as per Marks and Spencer. This is because the related nature of the retainers place the firm in conflict, as the matters cannot be approached with nothing in mind but the protection of interests, as put in Uni Oil. The professional rules and relevant case law reflect the emphasis placed on the protection and promotion of public confidence in the profession, and discourages the appearance of disloyalty, which may damage the public perception of the profession's integrity. Having considered the above guidance, Michael should move on to generate potential options, the weighing of which may be influenced by the model of lawyering he identifies with most strongly. Option 1 and 3 are in accordance with professional rules and in the interest of fulfilling fiduciary duties, ultimately acting in Romeo and Juliet's best interests. However, with Option 1, the conflict may not be completely addressed, and Option 3 results in the loss of the client and impacts performance targets. Option 2 is attempting to respect Juliet's rights to confidentiality, but is acting unethically nonetheless in direct breach of the conduct rules and neglecting duties to the court, the client, and the community at large. Especially relevant views to consider include Rhodes' argument that lawyers need to take personal moral responsibility for their actions and cannot reframe and rationalize it as being in the client's best interests, and Wendell's proposition that lawyers should prioritize fidelity to the law. Moving on to decision-making, Michael must now act on his judgment, ideally in a manner that prioritizes moral demands through consulting his moral motives. Moral motives are forces behind acting on judgments, which include common morality and covenants and fair bargains, the former being driven by the same sources as ordinary moral compliance, which in this situation will prevent him from acting on the confidential information to Juliet's detriment to benefit Romeo. The latter being the motivation to live up to the legal profession's end of the social bargain that provides it with status and privileges. Obstacles to this can include egoistic desires which overwhelm the moral conscience, psychological processes like cognitive dissonance which can erode important moral values, and misplaced loyalties to clients which can influence the reasoning process. Acting on his moral motives, Michael chose Option 2.
We now move on to the action stage of the rest and breaking model. This involves translating decisions into action and requires moral character in the form of virtues such as courage, perseverance, and kindness. In reviewing the available options, Michael chose to stay silent, in the hope that he could continue to represent Romeo without anyone else finding out about the concurrent conflict. This action involved essentially no positive elements of moral character. It was hardly courageous for him to take that course of action. However, there are a number of barriers to moral character that may be relevant here. These may include conformity with or deference to authority figures, such as senior partners in a law firm. This may have subconsciously compelled Michael to remain silent. He may have feared repercussions or judgment from his peers if he chose to bring attention to the conflict. This is understandable considering Michael is a new employee at the firm and was probably worried about his job security. We now move on to stage 5 of the rest and breaking model, the achievement stage. This requires using the first 4 stages to successfully implement moral decisions and requires moral competence, such as strong interpersonal or social skills. As with the previous step, this step appears to have involved a large amount of inaction by Michael and required minimal moral competence in its achievement. However, factors that may have benefited his moral competence and allowed him to achieve a different, more ethical outcome include greater informational gathering capacity, greater experience, and greater familiarity with the norms and practices of his firm. In time, Michael may develop these strategies for moral competence, allowing him to make better ethical decisions in future dilemmas.
The review step involves moral reflectiveness, requiring evaluation and reflection on moral action and consequences. If the case is still ongoing, Michael can still notify the court of the conflict and act in compliance with the Australian Solicitor Conduct Rules. Even if the case has concluded, he could, as a sign of good conscience, report the conflict anyway, which may result in a retrial or rehearing in the pursuit of the effective administration of justice. However, this would likely result in the professional ramifications for himself, Saul, and their firm. At the very least, Michael should reflect on the ethics of his conduct and the consequences, as it may inform him to act differently in future cases, or may lead him to seek further ethics education. However, there are many barriers that could truncate or altogether prevent Michael's review process. Long hours and time pressures may leave Michael unwilling or unable to take the time to review the situation. A culture of rationalizing after the fact could lead to a denial of responsibility, whether in the form of justifying his conduct, in preventing his client from being subject to delays, or reframing the situation to place the blame on Juliet or Saul. Michael may also fall back on euphemisms to minimize the perceived harm and unethical ramifications. An overconfidence bias could also lead Michael to believe a moral review is unnecessary, as such situations will be easily resolved in the future. Whilst Michael's inaction was successful in avoiding any unethical misuse of the confidential information, such conduct also failed to hold Juliet accountable to her disclosure requirements and also failed to address the conflict of interest under Rule 11.4, as he continued acting for his client after receiving confidential and detrimental information. If the matter is yet to conclude, Michael still possesses the opportunity to act ethically in disclosing his knowledge of confidential information, thereby withdrawing from acting on Romeo's behalf pursuant to Rule 11.4. However, whilst this would affirm a responsible lawyering approach and is consistent with notions of a moral activist approach, it would conflict with an adversarial activist's approach, whilst possibly being construed as failing to act in his client's best interest and potentially damaging both the firm and his career. In conclusion, Michael's moral reflection on his conduct should enlighten him as to how his inaction was not only non-compliant with the ASCR, but also failed to act ethically in his client's, the community's, and the legal system's best interests. It is recommended that improvements are made to the firm's conflict check procedure by implementing an automated system that cross-references existing and historical clients across a national database when creating new matter, requiring a second person to sign off on the conflict check, thereby reducing the likelihood of ethical blind spots and ethical fading causing a conflict of interests, and introducing educational requirements as to enable fully informed consent on behalf of the client before the conflict check can be completed. Regarding improvements to information barriers, mere physical separation may be insufficient. Thus, strict regulation and monitoring surrounding the disclosure of confidential information, firm-wide education on the operation of information barriers, and disciplinary action around deliberate or inadvertent disclosures are recommended. Furthermore, ad hoc information barriers should be avoided. Instead, established and tested barriers should be utilized to protect confidential information. The suggestions listed below highlight areas in which Michael or the firm could improve to facilitate a more effective application of ethical decision-making models in the future, as to avoid concurrent conflicts of interest. Specifically, emphasis should be placed on avoiding unrealistically optimistic expectations involving relying on others to resolve unethical situations, and periodic ethical training to refresh solicitors' awareness of ethical issues and further aid lawyers in implementing ethical decision